Good evening again. And now, finally, I am hoping that everything will work out. Please do let me know. Don't tell me again there is a glitch. Just a second, let me open the link.
The Myntra end of reason sale is coming soon. Get 50 to 90% off. Myntra, save on fashion, save fashion.
Okay, so I'm hoping you guys are able to. I don't know, by mistake, I closed the chat box and now I'm not able to access it. Just give me a second. Today it's a day full of glitches. The whole point is, are you able to hear me? Just let me know that, huh? I mean, I hope there is no voice issues anymore. You just give me a minute. Okay, so What is wrong with this? Can one of you just message me whether this is working? I'm like not able to figure out. No voice issues, then in that case I'll continue. Without the messages, I'll continue. By mistake, I closed that and somehow I'm just not able to open it. So chalo. Anyway, I'll just start with this. Since there is no voice issues, I think it is not an issue at all. So moving on to the next one, and most of you have my WhatsApp number. So if there is any doubt, please message me on my WhatsApp so I can see it. Okay. Sheetal was a classical dancer. She entered into an agreement with Sharad Vidya Mandir for 50 dance performances. So this is for dance performances. So this is obviously live dances, and so obviously time is of essence. As per the contract, she was supposed to perform every weekend and she'll be paid 8,000 per performance. However, after a month, she was absent without informing. If time is of essence and you fail to perform within time, the contract is what? Voidable. Due to her personal reasons. Answer the following questions as per the Indian Contract Act. Whether the management of Sharad Mandir has a right to terminate the contract. Yes, the contract is voidable. When the time is of essence and you fail to perform within the time, the contract becomes voidable. If the management of Sharad Vidya Mandir informs Sheetal about its continuance, can the management still rescind the contract after a month on the grounds of on this ground subsequently? If the management of Sharad Vidya Mandir decided to continue, so see, when the contract is voidable, we can either cancel it or accept it. Once we have accepted it, we cannot later cancel it. The point is a voidable contract once ratified cannot be cancelled. They have mentioned that they want to continue. So when they mention that they want to continue, they have accepted it. And once accepted, it cannot be cancelled. So can they cancel it subsequently? No. Can Sharad Vidya Mandir claim damages that it has suffered because of his breach in the above case? Now see, when the contract is voidable, you may either cancel it or accept it. When you cancel the contract, you have a right to claim damages. On the other hand, when you accept the contract, you can claim damages if it is mentioned, otherwise not. Here, if they cancel it, it is their right to claim the damages, right? It is their right to claim the damages. On the other hand, if they accept it, they can claim the damages only if they mention. Now, when I say they can claim the damages only if they mention, where will they actually mention it? It can be mentioned either in the contract or it can be mentioned at the time of accepting the contract. Paridhi, a minor falsely representing at age. So I already told you about this point that whenever there is falsely representing the age, generally we are talking about a minor can always plead minority, right? But the point of minor can always plead minority actually comes, the point of minor can always plead minority actually comes only when the contract is cancelled or we go to the court, right? And there he is asking that I am a major, I am a minor, I am not a major. Now enters into an agreement with an authorized laptop dealer, Mr. Mittal, owner MP Laptops, for purchase of laptop on credit amounting to 60,000 on the 1st of August 22. She promised to pay back the outstanding amount with interest at the rate of 16% per annum by 31st July. She told him that in case she won't be able to pay the outstanding amount, her father, Mr. Ram, will pay back on her behalf. After 1 year, when Paridhi was asked to pay the outstanding amount with interest, she refused to pay the amount and told the owner that she's a minor and now he cannot recover a single penny from her. She will be a major on the 1st of Jan and only after that agreement can be ratified. Explain which of the following is ways Mr. Mittal will succeed in recovering the money. By filing a case against Paridhi. No. No. And you would say that, ma'am, she is falsely representing her age. If he files a case, he can recover the money. No. When a minor fraudulently enters into a contract and the other party cancels the contract, the minor can prove that he is a minor and he is not liable to pay anything at all. So even if he files a case to recover the money, he will have no remedies against the minor. By filing a case against Mr. Ram, father of Paridhi. Now, as far as the parent of a minor is concerned, the parent of a minor is liable only for the acts for which they have given an authority. If for any act they have not given any authority, then they are not liable. Here, in this case, when we talk about Mr. Ram, there is nothing given about Mr. Ram having given authority. So since Mr. Ram has not given any authority, obviously the amount cannot be recovered from Mr. Ram. By filing a case against Pai, a minor, for recovery of outstanding amount after she attains majority. No. Why? Because a minor's act cannot be ratified. And even if you file a case against the minor after the minor attains majority, we still have no remedies against the minor. Why? Because a minor's act cannot be ratified. I hope this is clear to everyone. Yes? Moving on to the next one. Rohan found a wallet in a restaurant. Finder, found a wallet, finder of the goods. And whenever we talk about finder of the goods, which type of contract is it? We are talking about a quasi contract, correct? He enquired all the customers present there, but the true owner could not be found. He handed over the same to the manager of the restaurant to keep the wallet till the true owner is found. After a week, Rohan went back to the restaurant to inquire about the wallet. The manager refused to return it to Rohan. Now, the finder of the goods is the owner. Finder is the owner against the whole world except the owner. This means what? If tomorrow if tomorrow the owner comes and claims the goods from the finder is liable to return the goods back because owner is the owner of the goods. But if anyone other than the finder claims the goods, the owner is not liable to return the goods at all. Right? The owner is not liable to return the goods at all. Only he is liable. So against the whole world, the finder is the owner, but in front of the owner, obviously he has no rights over the goods. After a week, Rohan went back. The manager refused to return it to Rohan, saying that it did not belong to him. Can Rohan recover? Yes, because he is the owner unless the owner is found. Mr. Sohan, a wealthy individual, provided a loan of 80,000 to Mr. Mukesh on 26th Feb. The borrower, Mr. Mukesh, asked for a further loan of 1,50,000. Mr. Sohan agreed but provided loan in parts on different dates. He provided 1 lakh on 28th Feb and remaining 50,000 on 3rd March. On the 10th of March, Mr. Mukesh, while paying off part 75,000 to Mr. Sohan, insisted that the lender should adjust 50,000 towards the loan of 3rd March and the remaining towards the loan of 26th Feb. Mr. Sohan objected. Now the first question is, whenever the debtor makes the payment, who has a right to decide? The debtor. Can the creditor object to this arrangement? No. When the debtor makes the payment, the debtor has a right to decide which debt he wants to set off. And if the creditor accepts the payment, he must set off that debt only. So, decide whether Mr. Mukesh's contention is correct. Yes. Because when the debtor makes the payment, he can specify which debt he wants to set off. And if such a specification is given, the creditor, if he accepts, he must set off that respective debt only. What would be your answer in case the borrower does not insist on such order? So if the lender does not specify anything at all, the creditor may, at his discretion, set off any debt, including a time bar debt, but he cannot set off a disputed debt, right? Though time bar debt here is not applicable because no debt is time barred as of now. What would be the mode of adjustment of such part payment in case neither Mr. Sohan nor Mr. Mukesh insist? If both do not specify anything, the debt first in order of time will be set off first. So chronologically, whichever debt is first will be set off first. I hope along with me you are also able to figure out the answers. If you are, so it kind of gives you a confidence that yes, I know the text and I'm actually prepared for the exams. State with reasons whether the following agreements are valid or void as per the Indian Contract Act. Where two courts have jurisdiction to try a suit, an agreement between the parties that the suit should be filed in one and not in the other. It's absolutely valid. See, when you prohibit going to the court, okay, when you prohibit going to the court, that you cannot go to the court, then it is void. But when you restrict going to the court, then it is not void, it is absolutely valid. Right? Then it is not void, it is absolutely valid. X offers to sell his Maruti car to Y. Y believes that X only has a Wagon R car but agrees to buy it. He did not say which car he is talking about. He did not understand which car he is talking about. There is no consensus ad idem. There is a mistake to the identity of the subject matter. The contract is what? Void. X, a physician and surgeon, employs Y as an assistant, salary of 75,000 per month for a term of 2 years. Y agrees not to practice as a surgeon and physician during these 2 years. It's a restraint of trade, but we already saw that any agreement which is in restraint of trade, if it is reasonable, it is absolutely valid. Since the term is that till you are working for me, you cannot practice anywhere else. It is absolutely reasonable. And since it is reasonable, it is absolutely valid. Mr. an industrialist, has been fighting a long drawn litigation with Mr. Raman, another industrialist. To support his legal campaign, Mr. Seth enlists the services of Mr. X, a legal expert, stating that an amount of 5 lakh would be paid if Mr. X does not take up the case of Mr. Raman. Mr. X agrees, but at the end of the litigation, Mr. Seth refuses to pay. So this is kind of in restraint of, legal proceedings or interference with the course of justice. So you are making a contract which is against public policy. And when an agreement is against public policy, it is what? Void. So can he recover the amount promised? No. Why? Because it is void. What are the consequences of destruction of specified goods before making of contract and after agreement to sell under the Sale of Goods Act? So now till here it was Indian Contract Act. Now we have started with the questions of Sale of Goods Act. So moving on to this one. By mistake, I actually closed. I don't know. I obviously would be able to open, but I'm not able to open. Anyone has any doubts till this point? Just a minute to open the file. If anyone has any doubts. I don't know, today it has been a very glitch day. Anyway, what are the consequences of destruction of specified goods? Okay. Uh, when we talk about specific goods, if without agreement only the goods are destroyed, the contract is what? Void. If after agreement before sale, and this is what void ab initio. This is basically bilateral mistake of fact. After agreement but before sale, if specific goods are destroyed, the contract is void. Now, this is not void ab initio, this is void contract, destruction of subject matter. On the other hand, if the goods are uncertain goods, the contract is absolutely valid. What are the implied conditions in a contract of sale by sample? So basically, when the sale is made by sample, no. When the sale is made by sample, just a second, it will not work. Get it. So yes, when the sale is made by sample, the bulk must correspond to the sample. The buyer must be given an opportunity to examine the goods before he accepts them, and the goods must not have any latent defect. Latent means hidden defect which cannot be found on examination but makes the goods unmerchantable. Also state the implied warranty. So there are basically four warranties. Warranty as to undisturbed or quiet possession. This is basically condition as to title, treated as warranty. The second one is warranty as to freedom from encumbrances. The third one, warranty as to disclosure of dangerous nature of the goods. And the fourth one, which is again a condition treated as a warranty, warranty as to quality and fitness by usage of trade. Shubhangi went to a jewelry shop and asked the sales girl to show her diamond necklace with sapphire stones. The jeweler told her that we have a lot of designs of diamond necklace but with blue stones. If she chooses for herself any specific design of diamond necklace with blue stones, they will replace the blue stones with sapphire stones. But for the sapphire stones, they will charge some extra cost. Shubhangi selected a beautiful designer necklace and paid for it. She also paid the extra cost. The jeweler requested her to come back a week later for delivery of the necklace. So basically, this is what? Agreement to sell for future goods. Correct or not? When she comes after a week to take the delivery of the necklace, she noticed that due to the sapphire stone, the design of necklace has been completely disturbed. Now she wants to terminate. See, when the sale is made, when it's an agreement to sell for future goods, the goods must be as per the description that I have given. Now, if the goods are not as per the description that I have given, am I bound to accept the goods? No. But ma'am, I mean, he has done whatever she said. Yes, but as a you are the jeweler, you would know. You are the owner of a jewelry store. You would know whether a design could come out or not. I, as a customer, may not be aware of that. So it is your duty to inform me if it will not come out as per the requirement. So, can she recover the amount? Yes, when the sale is made for future goods and a description of goods has been given, or I have told you kind of goods I am looking for, then it is your duty to supply me the goods which suit, which is as per what I want, not as per the or whatever. Here it is not applied condition as to the requirement of the buyer. So it's an agreement to sell for future goods. I am asking you for a particular type of goods. If the goods are not suitable for that particular purpose, can I return the goods back? Yes. Sorry. If the goods are not as per what I had asked for, they are not as what I wanted, can I return the goods back? Yes. So, can she return the goods back? Yes. Can she recover the amount from the jeweler? Yes. What would be your answer if the jeweler said he can change the design but he will charge extra cost for the same? I am not liable to pay the extra cost. You asked me to pay extra for the sapphire which I have already paid. Since I've already paid extra for the sapphire, it was your duty to give me the design wanted. You could not give me the design that I wanted. I'm not liable to pay you anything extra here. Correct? Then state the various essential elements involved in the sale of unascertained goods. After this, I will just wait for minutes. I'll clarify your doubts and then we'll move forward. In case of unascertained goods, the goods must be ascertained and appropriated. Ascertaining means the goods must be identified and set apart. The goods must be to a deliverable state. The appropriation must be done with the consent of the seller and the consent of the buyer. That is with the consent of both the parties. That the seller with the consent of the buyer, or the buyer with the consent of the seller. And the goods must be unconditionally appropriated. So these are the essentials of appropriation, of transfer of ownership of the unascertained goods. Now, before I move forward, anyone has any doubts in any of this, you please ask me and then we will move forward. So someone here has a doubt. If the dancer dies, okay, if the dancer dies, can I recover the money from the what do you say, the legal heirs? Obviously, you can recover the advance from the legal heirs, but no, you cannot claim any damages from the legal heirs. Okay. Anything else? So I'll move forward with the next question. No, don't worry. Next live session won't be so much of a problem. I'll keep another laptop with me. So today everything was a little haphazard. Mrs. Kanchan went to the local rice and wheat wholesale shop and asked for 100 kgs of basmati rice. The shopkeeper quoted the price of the same as 125 per kg, to which she agreed. Mrs. Kanchan insisted that she would like to see the sample of what provided to her by the shopkeeper before she agreed upon such purchase. The shopkeeper showed her a bowl of rice as sample. The sample exactly corresponded to the entire lot. She examined the sample casually without noticing the fact that it contained a mix of short and long grains. The cook, on opening the bag, complained that the dish, if prepared with this rice, would not be of the same quality. Now she wants to file a case of fraud. No. She examined the sample. It was her mistake that she did not check it carefully. She will have no remedies of returning it back. What would be your answer in case she specified her exact requirement as to the length of the rice? If she specified her exact requirement as to the length of the rice, in that case it would have been for the specific purpose of the buyer. And in that case, can she return the goods back? Yes. Ravi sold 500 bags of wheat to Tushar. Each bag contains 50 kilograms of wheat. Ravi sent 450 by road and remaining 50 bags was himself taken away by Tushar. Before Tushar receives the delivery of 450 bags sent by the road transport, he becomes bankrupt. The goods are in transit. The person is bankrupt. I can exercise what? Stoppage in transit. Ravi, being still unpaid, stops the bag. Can he stop? Yes. The official receiver claims the goods. No, they cannot claim the goods. What do you mean? So here we end with Sale of Goods Act. We start with partnership now. What do we mean by partnership for a fixed period, which is formed for a specific period of time? Once the period is over, the firm is dissolved. But if the partners want, they may continue. It becomes a partnership at will. Continuing guarantee can be revoked. So in case there is no agreement to the contrary, any change in the constitution of the firm results in the revocation of the continuing guarantee. What do you mean by goodwill? Goodwill is a property of the firm subject to a contract between the partners. So basically, when we talk about goodwill, like any other property, this is also considered as a property of the firm. Messrs. ABC Associates have been a partnership firm since 1990. Mr. A, Mr. B, and Mr. C were partners in the firm since the beginning. Mr. A, being a senior partner, 78 years, transfers his shares to his son, Mr. Vikas, a CA. Mr. B and Mr. C were not interested that Vikas join the firm. Transfer of shares can take place only with the consent of what? All the parties. It can take place only with the consent of all the parties. After some time, Mr. Vikas felt that the books of accounts were displaying only a small amount as profit despite a huge turnover. Right? Just a second. Despite a huge turnover, it was only showing he wanted to inspect the books of accounts. When you are a transferee, the transferee, other than getting his share of profits, he has no rights. He cannot interfere with the business, nor can he check, inspect, and copy the accounts of the. So, however, the other partners believe that he cannot challenge. Can Mr. Vikas be introduced as a partner if his father wants to retire? Only if all the others agree. As an advisor, help them resolve the issue. He cannot check, inspect, or copy the accounts of the firm. Explain the various effects of insolvency. Insolvency of a partner, the partner is no longer a partner of the firm. Generally, a firm is dissolved, but if the partners want, they may continue. Even if they continue, partner is no longer a partner of the firm. The partner who is insolvent shall have no personal liability against the debts of the firm. He will have no rights over the firm. Whatever his share is in partnership, it will be used to pay off his debts in partnership. Master X was introduced to the benefits of partnership of Messrs. ABC and Company with the consent of the other partners. After attaining majority, more than 6 months have lapsed and he failed to give a public notice as to whether he elected to become a partner or not. If he fails to give notice, he automatically becomes the partner of the firm. Mr. L, a supplier of material, filed a suit against the firm. To what extent X will be liable? So basically, X is liable just like any other partner. Can he recover his debt from X? Yes, he can recover his debt from X because when a minor becomes a partner of the firm, he is liable not from the day he becomes a partner, but from the day he was admitted to the benefits of the firm. State whether the following is partnership. Two firms, each having 12 partners, combined by an agreement into one firm. Yes, the firms are not joining, the partners will join and form a single firm. A and B co-owners. Just because you see co-owners doesn't mean it cannot be partnership. They are doing business in common profit. Are they partners? Yes, absolutely. Some individuals form an association to which each individual contributes 500 annually. Objective is to produce clothes and distribute the clothes free to war widows. No, it is not partnership. Why? The motive of partnership is always profit. The motive here is not profit. And a non-profit organization is never partnership. A and B co-owners share. Now here rent. Please always remember sharing of rent is never partnership. Right? Sharing of rent is never partnership. A and B buy commodity X and agree to sell the commodity with sharing the profits equally. This is partnership, right? They are doing business, they are sharing profits. Is it business? Absolutely. Discuss the conditions under which LLP will be liable and will not be liable for the acts of the partners. Any act done by the partner under the authority of the LLP makes the LLP liable. But if LLP proves that the act was not done with their authority or the third party knows that the act was not done with the authority, then the LLP is not liable. Now, in case of fraud, LLP and partners will have unlimited liability. But again, if LLP proves that the fraud was done without the authority of LLP or the LLP was not aware of it, then LLP is not liable. ABC and its subsidiary KL Private Limited 90 and 70,000 shares in PQ. Okay. PQ has 3 lakh equity shares, of which 90,000 is held by BC and 70,000 is held by KL. What is the relation between BC and KL? BC is the holding of KL. Correct? Now, directly it is holding 90, but indirectly with this subsidiary it is also holding 70. So what is the total holding? 1,60,000. Is it more than 1,50,000, which is more than half? Yes. Yes. So is it? So analyze whether PQ Private Limited is a subsidiary of BC. Yes. What would be your answer if KL was holding the whole 1,60,000? That means if KL is whole of the 1,60,000. In that case, BC is not directly holding anything, but through its subsidiary, it is holding how much? 1,60,000. Is 1,60,000 more than 50%? Yes. So is it still? The answer would still be the same. Narendra Motor is a government company. Shah Auto Private Limited has 10 lakh equity shares. Narendra Motors is holding 5 lakh 5,000 shares. Can I say it is more than 50%? Yes. Can I say Shah Auto is a subsidiary of Narendra Motors? Yes. Narendra Motors is a government company. Shah Auto is a subsidiary of a government company. So can I say Shah Auto is also a government company? Yes, because definition of government company says subsidiary of a government company is also a government company. So advise whether Shah Auto is a government company. Yes. With this, we are done with the discussion of RTP. I know today there had been a lot of glitches. I'll make sure from at least the sound is done. So next day, live chat will also be there. I will be interacting. But anyway, last 2 minutes, if you have any doubts, you can ask me before I actually end the session. Okay? If you have any doubts, you can ask me before I end the session. Consent means agreeing. Oh my God, who is this guy with name only? Locha. Thank you so much, bus God, whatever your name is for the house, whoever message. Thank you so much. So I guess there is no doubts at all. Yes. So next day I am going to do a live stream on the mock test. So the institute had actually conducted a mock test